We are ready. People versus Daniel Rotan, case number 245286.
Sierra Coke on behalf of the people.
Richard Trush on behalf of Mr. Roten.
Thank you. Record should reflect the defendant present here. Mr. Rotan, present here in the courtroom today. This is the date and time set for sentencing. Sir, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sir.
Okay. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that?
No, Your Honor.
Oh, or any additions, deletions, or corrections?
There's a $50 court cost that was left off. State costs. I'm sorry, state costs.
Okay. Do you have any business that wish to address the court today?
No.
Anything on behalf of the people for allocation?
Your Honor, I appreciate that Mr. Rotan has taken responsibility for his actions. I think we've resolved this in a fair way. I know from having worked this case since the beginning of it, that he perhaps has the influence of people who need anger management, but he seems to have taken responsibility. The recommendation is appropriate. I hope he learns from that. He doesn't have a very extensive criminal history, retail fraud, and a couple of marijuana cases. He's 28 now, so I think he's growing up and seems to be maturing, and I hope he sees how this was viewed by law enforcement and why they responded the way they did. And I'm glad that he has pled this case out, because I think it shows that he knows he did something wrong, and I think that's important in this case specifically. So I'd ask the court to follow the recommendation. Thank you.
Yes, Your Honor. So, I mean, first, again, he has very limited prior criminal history. And as I see it, and again, as the prosecutor said too, it's limited to a couple of marijuana charges. Again, I think maybe a retail fraud in there, but very limited prior criminal history. The circumstances here are unique, and it's unique in the sense both of the statute here and I think in terms of what happened here. So, I mean, we start with the statute, which is a very, very broad statute, and I think rightly so. The situation here is one in which there was a suggestion of infidelity between him and his girlfriend. He went and was confronting his girlfriend and the person who was allegedly this occurred with. The confrontation, I don't think actually went terribly bad. They had a discussion about it, and both parties seemed to agree that at the end of the discussion, they'd sort of resolved it and they buried it. During the discussion, I think some things that are said in anger that are inappropriate. And the reality is the context of where his girlfriend works and where this happened is really controlling, and what makes this the reaction the way that it is. I think probably every single person here has said something in anger that they would regret. For Mr. Roten, it happened to be that when he said this, and I don't think he meant it, I've seen nothing from him either in his past or in my interactions with him that suggests that he's a violent person. When he said the thing, he happened to be on a school. We live in a time where things like that are taken as serious as anything can be taken. And it's understandably why. I mean, the history of what you see, I mean, what you see on the news tells us why these things are taken as seriously as they are. For Mr. Roten, again, it's difficult because to quote the judge at Bindover, right? We look at someone's intent, and the best example of their intent is what they said. I'm not sure I agree with that, but we don't have any other way to know what he was thinking when he said it. We can't read his mind to see if he intended to do this or not, and that's why it's treated the way that it is. I don't believe that he is a violent person. There's nothing in his history to suggest that. Since he's been on bond, he's complied with all the conditions that he's had of bond. Frankly, I think this is an unfortunate situation. I would agree with the prosecutor, and from discussions with Daniel, I think he does need to take a look at some of the people he surrounds himself with. I don't think that they're all a particularly good influence on him, and I think that some of that may have led to this. But at the end of the day, the recommendation here, I think, is reasonably appropriate. I think that the prosecutor has been reasonable in terms of how she's viewed it and how she's handled it. including keeping the offer to a misdemeanor open after running the exam, which again, isn't always her policy. So at the end of the day, I think the recommendation here is reasonably appropriate, would ask the court to follow it.
Thank you, Mr. Roden. Anything that you wanted to say today? All right, I did read through the report. I'm familiar with what happened here. Mr. Trush is exactly right. In this day and age, cannot afford to not take that kind of statement seriously and really act very aggressively on it. And so you've got to understand that you just can't make comments like that and not expect there to be some consequences to it. So I hope that you did learn from this circumstance and understand that words have meaning, words have power, especially words like that in this day and age. I do think that the recommendation for some probation is appropriate. Make sure that you have some supervision over for a short period of time. Yeah, I don't think all things considered it's necessary to emphasize the point here. So the court is going to follow the recommendation, place you on probation for a period of time here. Adopt all the terms and conditions as the terms and conditions of your probation, which if things go well, you would be eligible to be discharged early. So the more you're in compliance, the more you're taking it seriously, the better chance that you won't have to do the full 12 months on probation. The court is going to impose 36 days in the proper common jail with 36 days served. The crime victim's assessment of $130, the state cost of $50, the court cost of $325, attorney fees of $350, the supervision fee while you're on probation of $30 per month, and DNA testing fee of $60. During the time that you're on probation, the court is also follow the recommendation for being on the property knowledge for the recommendation. You have the ability to seek an appeal of this sentence if you want to do that, you file for that appeal within the next 21 days. If you have more questions about that, Mr. Church will be able to answer those for you. Scope, anything further that we need to address in this file.
Well, good luck, Mr. Roden.
Mr. Church.
Mr. Roden just indicated to me he expects to make a payment on Friday, and I've talked to him about getting it paid. So
Okay.
I don't get a paycheck until Friday, and I can get it mostly taken care of it, not all of it.
Okay. And then does he need to report with you today, or
I'm going to talk with him right now. It's a misdemeanor.
Oh.
It took me a minute to catch up.
Okay, thank you. Good luck to you both.
Thank you.
And have you seen, we're a little bit ahead. Have you seen this?
Ms. Owens, I think, is going to appear via Zoom.
Oh.
She did show up in person on the 4th and was not aware that it got adjourned to today's date. So I did inform her of that.
Ms. Owens, if you're able to hear us, you need to go into your Zoom app and connect the audio on your Zoom app, please.
Hello?
Okay, yep, we can hear you now. Are you, ma'am, are you Jennifer Owens?
Yes, sir.
Okay, we're on the record in People versus Jennifer Owens. This is case number 2452889. The record should reflect Ms. Owens is attending this hearing today by video. Both counsel are present here in the courtroom. This is set for, I believe, a sentencing hearing today. Ms. Owens, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sir.
Okay, Mr. Trush, are there any corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the guidelines?
No.
Anything on behalf of the people for allocution today?
Ms. Owens presents with no criminal record, no juvenile record, no misdemeanors, no felonies. She's 43 years old. I always wonder when I see these cases with people of this kind of history, how they got this far with no history and then show up with methamphetamine. I hope that she takes this seriously. This is a very good opportunity for her to utilize the 7411, and then she'll have no criminal record, which will make her life a lot easier. So I would ask the court to follow the recommendation. Thank you.
Thank you, Mr. Trush. Anything on behalf of Ms. Owens today?
Yes, Your Honor, I would echo a lot of the same sentiment. Ms. Owens has no history whatsoever. I think she's a good candidate for the deferral under 7411. And frankly, I would echo from the prosecutor again that, it is always a little bit concerning when we see someone with no history, and showing up with something as significant as methamphetamine. I tend to think it's probably just more telling of how prevalent and available methamphetamine is right now. Those of us in the court system see it daily. But I think that the probationary term is good. I hope that if there is a substance abuse issue, that Ms. Owens uses that probationary term to address it. Because if she's back with more charges, she won't have the same kind of deferral options available to her. And, punishment tends to progress upwards. So I hope she does take advantage of it. I would ask court to follow the recommendation, with the only exception being, I would ask the court to consider waiving the court-appointed attorney fee of $350. And again, the PSI indicates there's not really any sort of substantial assets or any source of income. So that would seem to be an appropriate time to waive that.
Okay, thank you. Ms. Owens, is there anything that you wanted to say today?
Yes, sir. I understand everything, and it was my fault. I have to pay for the crime.
All right, I did review the pre-sentence report, so I'm familiar with what happened in this case and also familiar with your background, Ms. Owens, based on the information within that report. And, I think what the lawyers have indicated, I would reiterate, methamphetamine is not a substance to use recreationally. It's the kind of thing that can send you down the wrong path in a hurry and get you to a place where you have a lot harder time getting back to being clean and sober, or at least not using methamphetamine. So I would reiterate what the lawyers have said and state that I hope that you do use the probation that the court's going to order here. If you do need some kind of treatment with that substance, to take advantage of those resources and get some help. Otherwise, that you just refrain from being involved with methamphetamine, using it, possessing it anyway. I do think 7411 is an appropriate course of action here, given your lack of any prior criminal history. So the court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. The court is going to order that you serve 18 days in the Crawford County Jail with credit for 18 days served. The court is going to make that probation pursuant to 7411. The court is also going to order a crime victims assessment of $130, a supervision fee that can be paid at $30 per month while you're on probation. I am going to order the court costs and attorney fees. However, just so counsel and Mr. McFelda, are you the supervising agent?
I will, Judge.
Okay. If we get to the end of probation and it looks like that's just not a reality that she's gonna be able to pay those, I would consider waiving those later on, when she's discharged.
Okay, thank you.
But the court is gonna order those as part of the sentence here today, and that's $325 of court costs, $350 of attorney fees, a DNA testing fee of $60 and a $68 state cost. Because the probation is being ordered pursuant to 7411, there are no written appellate rights at this time. Mr. McFella, do you have any instructions for Ms. Owens in terms of how to get a hold of you?
Is your phone number still 248-363 or 636-5843?
Yes, sir.
I'm gonna call you later this afternoon, okay? Maybe around 4.
Okay.
Oh,
Sounds good.
Okay, thanks.
Thank you, Ms. Owens. Do you have any questions at all?
No, sir, they all got answered. Thank you so much.
Okay, good luck to you going forward. You're free to disconnect at this time.
Thank you. Have a good day.
This one's on Terry Johnson.
Terry's, okay.
Zach Johnson.
So we'll take a short recess and come back on the record at 2:15.
And I would, Mr. Johnson's already here.
Oh, are you-
He's in the lobby. I'll go get him.
okay. Perfect.
Jack Johnson's off. Adjourned.
He's off, okay.
And people versus Terry Johnson. We have 2 files, 5233 and 235269. The record should reflect Mr. Johnson's presence here today.
Your Honor, we do have an agreement that we intend to enter into. Apologies, I'm trying to find the case number so I can.
The offer is OWI 3 and 5233 FC. Dismiss all the habituals in DWS and open intox. And on the other file, if he enters this plea, which is 5269, he will have just an OWI first. And we'll dismiss everything else
Need to count one.
with no habitual.
So just to make sure that I understand that correctly, he's pleading to an OWI third, the 5-year offense, and then an OWI first offense, a 93-day misdemeanor.
Yes.
Okay, that's what I thought, and I think you did a better job of explaining it than I did. And the only other thing I would indicate, I think it is contemplated that he's going to be in the sobriety court in Roscommon. In fact, I think he's actually already started on a Roscommon case there.
Okay. All right, Mr. Johnson, have you had a chance to speak with Mr. Trush about this plea agreement? Yes, sir. Okay. Is that how you want to proceed today? Yes, sir. Do you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Okay. Lower your hand. Mr. Johnson, are you currently on any kind of probation or parole? No, sir. All right. And you understand that in the one file, you're going to be pleading guilty to operating while intoxicated as a third offense. That makes that with a maximum possible penalty of up to 5 years and or a $5,000 fine. Understand that? Yes, sir. And then in the other file, a misdemeanor operating while intoxicated, which carries with it a maximum penalty of up to 93 days and or a $500 fine. Do you understand? Yes, sir. With those penalties in mind, what is your plea to those charges today? Plead guilty to all charges. Okay. So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you. and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir.
Does anyone threaten you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we said here in court today?
No, sir.
Your own free choice to enter this plea.
Yes, sir.
Are you pleading guilty because you are in fact guilty of each of these charges?
Yes, sir.
So the older one that occurred back on July 6th of 2023, is that the correct date?
That is correct.
On that date, had you been consuming some alcohol?
Yes, sir.
And after consuming alcohol, did you operate a motor vehicle on Chase Bridge Road here in Crawford County?
Yes, sir.
And had you consumed enough alcohol that your ability to operate that vehicle, you no longer have the ability to operate that vehicle in a normal, reasonably safe manner?
Yes, sir.
Did you ever have any blood or breath tests to determine the level of alcohol? Was it over the legal limit of 0.08?
Yes, yes.
Do you have any reason to doubt the accuracy of that test?
No, sir.
Then the next one was a couple months after that in September 24th of 2023. Do you recall that day?
Yes, I do.
And on that day, had you also been consuming alcohol?
Yes, sir.
And after you consumed alcohol on that date, would you operate a vehicle on Hines Trail here in Crawford County?
Yes, sir.
And because of your consumption of alcohol, were you unable to operate that vehicle in a normal, safe manner?
Yes, sir.
Do you have any blood or breath tests on that?
Yes, sir.
And was that over a 0.08?
Yes, sir.
Do you have any reason to doubt the accuracy of that test?
No, sir.
Had you previously been convicted of operating while intoxicated here in the district court back in 1990?
Yes, sir.
And then also in the 31st Circuit Court in 2019?
Yes, sir.
Ms. Koch, are the people satisfied with the factual basis?
Yes.
Mr. Church?
Yes.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Church, are you?
I'm aware of none.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Defense is satisfied.
Mr. Johnson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as the goal. We'll set this matter for a sentencing hearing, and just make sure you stay in touch with Mr. True prior to that hearing.
Your Honor, I would suggest, I think he has a bond condition that requires him to do daily PDTs. I would ask the court consider modifying that. He's reporting to the sobriety court. He's reported to me that he's testing 3 times a day there. Having him do PBTs for here, I think is just, it's an extra burden for him.
Is that the same facility he's been at before?
No, because he's,
If I may, I'm still dealing with ATS, Addiction Treatment Center, and I'm still in their recovery home. So the once a week thing that we've been doing is still good, because I have to drop anyway.
Oh, okay.
okay.
All right. Okay. Thank you. That's all for today then.
Thank
Judge,
you.
did you order a PSI done on this?
Oh, yeah. I'm sorry. Yes.
Okay, just making sure.
If I didn't say that, then that's.
Okay.
Next hearing is with Mr. Hickman at 2:30, so we'll take a brief recess and come back on the record at 2:30. People versus David Bigman, case number 204590.
Your call on behalf of the people.
Your Honor, Richard Church on behalf of
That for probation violation hearing today, Mr. Truce.
Thank you, Your Honor. This is a relatively new appointment. Looks like I just got appointed about 10 days ago or so. Had an opportunity to speak to Mr. Bickman as well as the probation department about this. I would indicate we don't intend to have a contested hearing. I think frankly, Mr. Bickman has made admissions that are likely controlling in Otsego County already. But I would ask for a brief adjournment just so that Mr. Bickman and I can have a little more in-depth conversation about what that looks like, what the exposure and sentencing here might look like. And I would indicate he's currently sitting on a year sentence in Otsego, so it's not as if he's going anywhere at the moment.
All right, Mr. Hagan.
Your Honor, I've been in contact with his former significant other, who's the mother of the child in question here regarding the violation. She doesn't mind the adjournment. She preferred to have it done sooner rather than later, but since he is incarcerated, as Mr. Truce stated, he's not going to go anywhere, but you know, personally, I would like to see this maybe resolved sooner rather than later as well. I mean, if there is a plea today, he wouldn't be sentenced for another month anyway, so leave it up to the court's discretion.
All right, I think given the status of the case and Mr. Bickman's status, it's not an unreasonable request. We set this out 30 days, Mr. Truce.
I would fully expect that we would be prepared at that time to make admissions.
Do you have any questions? All right, so the court will reset this about 30 days.
Thank you.
Versus Alexson, case number 235240.
Your call on behalf of the people.
Mr. Seeger is coming in person.
Oh, Seeger's on. He might be a little bit late. He said he's got hearings in front of Judge Hunter. Don't see. So, Mr. Alexson, if you could just stay here. For a minute. And the record is people versus 23524. So is present here with the counsel, Mr. Seeger, prosecutor. Mr. Seeger, how do you want to proceed?
Your Honor, it's my understanding that Mr. Ellison has been afforded an opportunity to plead to one count of possession of narcotics. In exchange, the balance would be dismissed.
That is true. It's possession less than 25 grams. The PAC code is 333.74032A5. That is a low severity felony with a maximum of 4 years and or $25,000.
And are we going to take the factual basis to the methamphetamine?
Yes, Your Honor.
Yes.
And Your Honor, I would note that he's on probation through Kilpatrick County, and I don't remember if you're the judge. It's Judge Hunter. I don't recall.
Yeah, okay. All right, Mr. Ellison, have you had a chance to speak with Mr. Seeger about this plea agreement?
Yes, Your Honor.
All right, and is that how you want to proceed today?
Yes, Your Honor.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Ellison, you understand that your plea here in this case today could affect your probation status,
Yes, Your Honor.
and that you could face some additional penalties for violating your probation in addition to whatever penalties that you would receive in this case.
Yes, Your Honor.
And that, as Ms. Koch indicated, the maximum possible penalty for this added count of possession of narcotics is up to 4 years. Do you understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and not have that silence used against you. The right to testify at a trial yourself if you want it. And all those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here today in court?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes, Your Honor.
So the information I have indicates that this happened back on May 14th of 2023, so almost a year ago. Is that correct?
Yes, Your Honor.
On that day, were you present here in Crawford County?
Yes, Your Honor.
But while you were present here in Crawford County,
Yes, Your Honor.
did you have any legal right to be in possession of any amount of that at that time?
No, Your Honor.
Ms. Koch, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Stewart?
Yes, sir.
Ms. Koch, are those people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Stewart?
No, sir.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in taking this?
Yes, Your Honor.
Yes, sir.
Mr. Ellison, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for sentencing hearing. Before you leave today, you're going to meet Mr. Haven. Okay. Mr. Haven with Mr. Haven to set up a pre-sentence interview, and then I'll make sure that you stay in touch with Mr. Seeger regarding your sentencing hearing. The court will send you this is the big time.
Yes, Your Honor.
Any further business?
No, sir.
No.
All right, thank you for all today. So our last case at 3:30. Okay, we're on the record in People versus Coon, case number 235256. The council put your appearances on.
Your folk on behalf of the people.
Yeah, I'm ready to go with the idea. Almost just you way.
Okay, and so we're on the record here today. We've got a motion to suppress and then just for status conference as well. I did get a stipulation by the parties to view the video, which I did have a chance to do prior to today's hearing. I've also had an opportunity to review the briefs and the legal positions of both sides. And so, Ms. Koch, did you want to present some testimony today? Or?
I do briefly. I have now Trooper Hebner here.
Okay. Trooper, you come forward. I'm going to have you stand right here in front of Ms. Medler. She's going to swear you in, and then I'll have you take the witness.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give today should be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Trooper, you can have a seat here. Please state your first and last name and spell both for the record.
Ricky Hebner, H-E-A-V-N-E-R.
Proceed when you're ready.
Hebner, where are you employed?
The Michigan State Police,
Where were you employed in August of 2023?
Crawford County Sheriff of Crawford County.
And how long have you been a police officer?
About 3.5.
Were you working on August 26, 2023?
I was.
Can you tell me what you did at the beginning of your shift?
At the beginning of my shift is I tested my radar.
Can you tell me how you test your radar?
It's a button you push a test and it goes to a function test.
And was there any malfunctions or any problems with your radar calibration that evening?
No, it wasn't.
Can you tell me what happened around midnight that evening? What did you observe?
I was in patrol driving. I was westbound on County Road 612. Observed a motorcycle coming towards me eastbound, coming down the, I guess, overpass on 612. I observed it going above the posted speed limit, activated my radar, tracked it going 69, 68, 67, blocked my radar out at 67. There's a lot of pitch audio noise with it. Vehicle, the motorcycle slowed down as it was passing me. Yeah, I heard it accelerate, and then I activated my rear radar and tracked it going 66, 67. I locked my radar out at 67.
Once you, what is the speed limit right there?
It's a 55-mile-per-hour zone.
And after you observed the motorcycle speeding, what did you do?
I conducted a U-turn.
And did you follow the vehicle?
Yeah, I got behind the vehicle and then observed it turn down Pearson.
What did it do after it went down Peterson Road?
I activated my lights and then I turned on the Peterson Road.
And where did the motorcycle go from there?
I turned down the shelter.
About how far did you follow the vehicle with your lights on?
I don't know the distance from 612 to Michelle. Now that's important. I don't know the distance there, so yeah.
When did the motorcycle come to a stop?
It pulled down Michelle Drive into the back of the residence there.
I want to skip ahead to the end of your shift. Do you have to test your radar at the end of your shift?
Yes, I did.
And did you do that in this shift?
Yes, I did.
Okay, and how do you know that you checked your radar at the end of your shift?
For me, best practice is after complaints that falls on speeding. That's after the complaint, but at the end of my shift, I just test my radar.
And you did that on this shift?
Yes, ma'am.
Did you have any problems with your radar at all?
I did not.
Now, there is a body worn camera that you were wearing during this incident. Is that true?
Yes, ma'am.
Did you review that for today's testimony?
Yes, ma'am.
Is it accurate as to what happened during your interaction with the defendant?
Yes, ma'am.
Were you wearing the body worn camera the entire time, or did something happen to it?
I was wearing it until it got knocked off.
I'm not gonna ask him any additional questions since it's all on the video and you've watched it, so I don't think I need to ask anything additional. Thank you.
All right, are you gonna, you want the court to admit that as an exhibit?
Yes.
Video? Do you have a objection?
No,
Okay, so the court will admit, and the copy I have says People's Exhibit 2. Are you gonna have any other exhibits? in this code?
No, Your Honor.
All right, so I'm just gonna remark that as for purposes of today's hearing. Mr. Gerber, any cross exam?
just thank you. I'm sorry, when you beginning of the shift, that's the radar, doesn't it print out something showing that the radar is calibrated and is accurately working?
No, sir, it's just a button that tests.
Okay, and does that button, once you hit the button, it doesn't give you a printout or a reading of any sort?
It has a reading display on the actual radar, but it isn't print.
Okay. And where do you log that once that radar display shows? How do you log that it was accurately tested and it is functioning properly?
On the top right, there's a radar pass check. Mark P for pass.
Okay. And at the end of the shift, you do the same thing.
Yes, sir.
And what do you do at the end of the shift?
Same thing as I write the time that it passes.
Now, this radar, the certificate of accuracy is from 2015, correct? Are you aware of that?
I'm not aware of that.
Okay. And are you aware that the radar has to be tested every so often to maintain its accuracy?
I don't do the testing for the department. I don't know if that would be.
Okay, and do you know when it was tested or have you reviewed that before today?
No, I don't.
Did you review that before of August 26th, 2023?
I have not personally.
I think was the witness.
Yes.
Well, handy what I believe is the log. Is that your handwriting, sir?
Yes, this is my handwriting.
And is that from August 26th?
In the 25th, like those. Yes.
Okay, would you show me at the end of the shift where you marked on that log and what?
Right here on my hand, sir.
Okay, and what does that indicate?
That's passed, that is passed, that's 6 times.
And would you show me where it's marked at the beginning when you?
Right above it, sir, passed 19.
Okay. One second, Judge.
Was the shift right? It's my trial. It's just my shift.
Now, once you activated the radar, was this a radar that was stationary in your vehicle, or was it a handheld device?
It might be a little station.
Okay, and you at one point testified that you then had your rear device radar on as well, correct?
It's an antenna. Yes, sir.
Okay.
There's an antenna at the front.
Okay. Do you have to test the rear antenna to check for the accuracy of the frequency?
I don't know if that would be a part of the radar calibration that goes with the whole
Okay.
system. when you go to calibrate that.
Now, at what point did you turn your lights on? Because on the video, I didn't see your lights go on until you were in the driveway.
So my lights were activated when he started to turn on Peterson.
Okay, so you turned the lights on when he turned on to Peterson.
Mr.
Cool.
Yeah, I think your client might want to talk to you. He's shaking his head at me. I don't know why he's doing that.
No, I was. You want to talk to me? Oh, come on. We're good, Judge.
Okay.
You said the lights were on when Mr. Kuhn turned on Peterson Drive.
It might have been further down there.
And then you said Mr. Kuhn turned on Mitchell Drive,
Michelle Drive.
Michelle Drive, okay. Isn't it the driveway before Michelle Drive that Mr. Kuhn turned into?
I think it's a shared type driveway. I'm not for sure.
All right, and he drove right to his house, correct?
I drove around the back.
But he went into his garage,
Yes, sir.
okay? And did Mr. Kuhn indicate to you that he was residing there? That was his house,
He did.
okay? And at that point, Mr. Kuhn indicated to you that he didn't want to have any police contact?
Yes, sir.
Okay, so why not just write him a ticket? It was a civil infraction at that, correct?
I did not know who he was, sir.
Okay. Were you not able to write him a ticket the next day? When Mr. Kuhn indicated he didn't want to have contact with you while he was in his home at that point?
Just taking the complaints heard and trying to identify.
Okay. And are you aware that he's not required to identify himself once he's at the house, when he's inside in his garage?
Your Honor, I'm gonna object. I think he's asking the officer to make a legal finding. It's also, I believe, not factual.
Well, I mean, testimony here is to get facts. If you want to make a legal argument, you're free to make that. Whether the officer, his opinion of the law is, I don't know, it's irrelevant. Court's gonna have to decide whether to.
And I don't have any further questions. Let's start the video then.
All right, Ms. Vogt,
No additional questions.
thank you. Trooper, you can step down. Thank you, sir. Any other witnesses, Ms. Coe?
No, Your Honor.
Mr. German, did you want to call any witnesses?
No.
Ms. Vogt, any argument?
No, Your Honor. I have fully briefed both the factual things that I believe are important shown by now Trooper Hefner's testimony and throughout the video and the legal status for the stop. Thank you.
Mr. German.
Judge, my argument, clearly, Mr. Kuhn is in his driveway, in his home at that point. Mr. Kuhn did not want to have any contact. He was in his home. At that point, believed that this was an unlawful arrest, at least at that point, because the officer tells him, I'm going to arrest you. I'm going to count down if you don't, submit. Again, the officer could have written him a ticket the next day, could have pulled him over sooner. He indicated he saw him on 612 go up to you fast. I didn't see in the video that on Peterson Road, his lights coming on. The lights came on once Mr. Kuhn was in on Michelle Drive, which is his driveway, going up the driveway. And at that point, again, Mr. Kuhn has no idea whether, it's a shared driveway that the officer was coming to get Mr. Kuhn, or whether the officer was going somewhere else on that shared driveway. And then in the video, you can hear the officer tell him, I'm going to teach you a lesson. I think for all those reasons, this was a wrong arrest, it was an unlawful arrest, and I would ask that the evidence here then be suppressed.
So let me ask you this, let's say that the trooper saw what he saw on his radar, and the trooper believes that Mr. Kuhn is exceeding the speed limit and decides to conduct a traffic stop. Mr. Kuhn doesn't stop until he gets to his house. What's the officer supposed to do at that point?
Well, I think that wouldn't be a fleeing elude if Mr. Kuhn didn't stop in a reasonable time frame when the lights went on.
They didn't charge him with fleeing and eluding.
Correct.
Okay, so what is the officer supposed to do at that? Does he just say, okay, well, I guess I'm gonna let this guy go and not give him a ticket for speeding?
Well, I think, again, he pulled him over once he was in his driveway, in his home. So at that point, the officer could have either given him the ticket, which was civil infraction, but the officer
Okay,
then.
but Mr. Kuhn refuses to turn over any paperwork at the request of the officer. So who's he supposed to just write it to a random person? Who's he supposed to write a ticket to? He's not given the identification. I'm just trying to get at what is a police officer under those circumstances supposed to do? Where the subject's refusing to give him proof of insurance, registration, identification. He's conducting a traffic stop, no speeding, pretty routine thing. what is the officer supposed to do at that point?
Well, he's conducting that in Mr. Kuhn's driveway.
So what?
I think that's where the issue is. If there was a civil infraction, the officer knows where he lives, he could have issued a ticket the next day.
Why
could've-
can't he issue a ticket that night?
He could have issued.
What's gonna happen by the next day that's gonna make anything any different?
Well, this would not have been escalated. That's what my client's position is, that now he feels, I'm in my house, I'm there. There's no criminal activity afoot. He didn't pull him over because he believed he was swerving or was drinking
I
and
know, I
driving.
understand, pull him over for speeding.
It was for speeding. He was already in his driveway.
He refuses to provide any documentation. So what is the officer supposed to do at that point? Does he just turn around and, hey, I'm trying to talk to your attorney? Okay,
I know, but
Stop. I'm trying to talk to your lawyer. Okay. All right? He's here to argue for you. This isn't the two of you both arguing. And I'm trying to ask him questions about a legal position.
Okay, all right,
And I don't need you interrupted.
I apologize, my bad.
So he's refusing to turn over any paperwork, which he's required to do. Is the officer just supposed to say, okay, well, I'm just gonna.
Well, my client's position.
No, answer my question.
Well, I don't think the officer is required to leave at that point, but I think the officer knows where he lives. There's other avenues, other ways. He could have ran his plate. He would have known who this bike belongs to.
What was wrong with what he did by asking for the identification? And then when Mr. Kuhn refuses to provide it, after multiple requests.
Yeah, I think the only thing wrong is pulling him in his driveway while he's in his garage. And then coming into the garage, which is at this point his domain, asking for essentially, give me your ID. I want to, it's a search at that point. At that point, it's not just voluntary, I'm pulling you over speeding. And that's where I think the issue lies, is whether this was on the side of the road where Mr. Kuhn, if he didn't comply, we'd be in a different situation. But Mr. Kuhn is in his driveway,
So if an officer tries to pull me over and I'm close to my home, I can just not stop, pull into my garage and say, you can't do anything to me anymore.
Well, I
Unless
think,
you want to charge me with fleeing.
well, I think if it's close to the home versus I'm in my driveway pulling into my garage, I think that's the difference. He's already going into his garage in his driveway. He wasn't trying to be pulled over a Peterson Drive or a Pretty Peterson Street. He wasn't pulled over by the overpass in 612. And I think the officer followed Mr. Kuhn to see if Mr. Kuhn, would swerve or, see if there were any additional civil infractions that could lead him to believe that a crime was being committed. But Mr. Kuhn was not drunk that day, wasn't drinking, wasn't committing any other criminal activity. And I think under Chavez, he's now required to then engage with the officer while he's in his home. And then, of course, the issue of Marino comes up where Mr. Kuhn then believes that this is a unlawful arrest on his part and then refuses to comply with the officer's orders because he believes he doesn't have to at that point. It's not on the side of the road. He has a different expectation of privacy in his home.
Any response to that argument?
Your Honor, I drafted a response. I explained why this isn't like Shiraz at all. And I cited the case law, People v. Ethington, that I think is applicable. And I think the officer's behavior was correct. And had Mr. Kuhn just complied and gave him his license, he probably would have got a civil infraction. This did not have to turn into the situation, but I don't believe it was the officer's fault. And I probably could have charged him with fleeing and eluding. I chose not to do that. That was my decision. Either way, I think the officer was more than lawful in his stop. He was polite to the defendant, and the defendant's behavior led to these charges. I would ask the court to deny the motion to suppress. Thank you.
Again, I did have a chance to review the legal arguments of the parties. I had a chance to review the video, which I think is really compelling evidence in this case. And I mean, Mr. Kuhn, you were being pulled over for speeding. It's clear you didn't think that you were speeding. You wanted to argue with the officer about that. I think the officer at that point is in the middle of conducting a traffic stop for a civil infraction. The fact that you didn't pull over sooner and drove into your property doesn't stop the officer from having the authority to continue his investigation into the speeding. I think you clearly, by statute, upon request, have to provide proof of insurance, registration, driver's license. on the video, it's the officer gave you many, many opportunities to do that. You could have done it. You decided you didn't want to do that for whatever reason. That's what happened. You can shake your head at me all you want, but that's what happened. I saw the video. And so at that point, you're really giving the officer no choice. And I understand the legal arguments, Mr. Murphy, that you're making, but I think there's clear distinction between the cases that you cited and what happened in this case. Again, the officer was clearly in the process of conducting a traffic stop. Mr. Coon drove onto his property, stopping immediately as he should have. He refused, and I think Trooper Hunter was quite patient with Mr. Coon through the whole process of asking him multiple times to provide the documentation, and he refused. And at that point, the officers made the decision that he wasn't going to comply, that he was obstructing the investigation, and they did the only thing that Mr. Coon really gave him the option to do at that point. So I just don't see that the officer did anything improper throughout the course of this transaction. And frankly, I don't know what else he would have done. It to me, it's completely unrealistic during a traffic stop for an officer to for someone to refuse to give the documentation that they're required by law to give, and expect the officer to just say, all right, well, I'm not going to do anything about this, or maybe I'll write you a ticket tomorrow. So for those reasons, the court finds that there's no basis to suppress the evidence in this case, and the motion is denied. And this code, did you prepare an order?
I did. It's attached to our response after Exhibit 3, but I have a copy if the court wants it.
All right. And then in terms of the status conference, Mr. Murphy, do you want the court to set that for a different date? You want to talk to Mr. Murphy about how
We can just take, we can take just 5 minutes, Judge. We can walk right out of the.
take a short recess and then we'll come back on the record in about 10 minutes.
All right.
Feel free to.
record. Mr. Gerber, how do we want to proceed today?
Judge, I had a chance to speak with my client, discuss the plea offer with him. He's rejecting the offer of trial is set for May 13th. We're ready to go to trial.
So, we'll be ready to proceed on the 13th.
We are. Mr. Gerbuthi and I are going to review the tape to make sure there's nothing inadmissible in that. If there is, I will either remove that section or sound it out. But off the top of my head, I don't think there's anything. I just have to check the lien traffic, make sure there's nothing in there that can't go through.
And I agree that there was, I don't believe there's anything that's inadmissible in there, but
We'll
if
double
there
check.
isn't, we would be just stipulating to the entire video being played in front of the jury.
Ms. Pope, I just asked that you submit, I know that you can submit the full text instructions tailored to this case. Mr. Gerber, just any instructions that you're objecting to or any additional ones that you want to submit a whole set.
Okay, I'm gonna likely have some special instructions, so I'm just gonna file that as a motion on limine, and we can, I'm not gonna set it for a hearing, Judge, but I think we can argue after the preliminary instructions and see how the trial, what comes in, what instructions, then special instructions need to come in. Because I know I'm gonna have the instructions from Marino, people in Marino, and perhaps some of the other cases. I know the Court of Appeals just came down with People versus Hull. So I'll just have that by way of motion limiting, but I'm not gonna set it for you.
Okay. Spoke any other matters that we need to address pre-trial?
No, not that I can think of. And frankly, I tried lots of cases with Mr. Gerbuthi. We get all of them solved beforehand.
Well, Mr. Gerber, any other issues that you anticipate?
At this time, no. You want my client here at 8:30, correct, Judge? 8:15.
We all need to be here at 8:30, ready to go, and Mr. Kuhn, just make sure that you stay in touch with Mr. Gerber as we get closer to trial so that you're prepared to go forward, okay?
And my client would ask same accommodations for our headphones on that day and so on.
Okay.
Thank you.
All right,